When Donadio told me we had the second to last spot on a Friday morning, I thanked him because I said, this is going to be great. We're going to get a group that's energized after 3 days of fasting, juice cleanses, and group calisthenics. I knew you guys were going to be absolutely ready for us, and nothing makes me happier. As I was driving down today, one of the members from John and my group texted me and said, knock 'em dead. And texting through my CarPlay, I said, the only fear of death is death from boredom, and it's my job to make sure that that doesn't happen today. So we're going to do our best to cover an important topic and a somewhat dense topic, but the plan is to go over a little bit of kind of the rules and regs side, and then Anthony, John, and I can share a little bit of what can go wrong. And I think that's when we start talking about that aspect, we can try to keep a little bit interesting. So the format we came up with is that I'll moderate kind of the panel and share questions with my colleagues. And the first question we wanted to address, and I would start with John, is before we talk about continuing disclosure, let's talk about disclosure a little bit. And John, from your decades of experience, can you talk a little bit about the why of disclosure?
Sure. Thank you, Tim. When I heard those introductions, it kind of scared Anthony and I, because we started in the business together, and we're sitting here looking at each other. It's like, wow, it's been 20 years now. It's like, we're just kids a while ago, so it's just a little bit of a wake-up call. So when I was talking to Tim and Anthony about this program, one of the things that I've always wanted to know when I was a lawyer, especially when I was a law student or whatever, is like, why do we do these things? Why, what is the purpose of it? Because it gets you to understand, like, some of these things get to be a pain in the neck, and you want to understand why we have to do them. So I'm going to give you just a little bit of a history here. The federal government had a very difficult time trying to regulate municipal bonds because of the 10th Amendment. They're not allowed, to the Constitution, not allowed to regulate municipalities in the securities markets. So they had to find a way to have disclosure in the marketplace. So we're going to go, over disclosure. So disclosure is important because it allows investors to evaluate the risk of the investment, and allows investors, to look at your financials ahead of time before they make the purchase or make the investment in your community. So that was kind of the wild, wild west for many, many years. And the SEC couldn't really figure out a way to get great disclosure on the financials of municipalities or local government entities. And because of the 10th Amendment, they couldn't do it directly. So what did they do? They figured out a way to regulate through the back door, and that was through regulating the banks and saying that you're not allowed to purchase bonds or notes or obligations of a local unit unless you get an official statement. So they mandated that the official statement be used in the securities marketplace. So up until that time, right now we do a tremendous amount of disclosure in our POSs. From what I understand, it predated me. The POSs, or the preliminary official statements, were really just bare bones skeletons before they went to market, and then after they sold the bonds, they kind of filled in all the financial information and the risks. And so the SEC did various amendments to Rule 15C 2-12, the regulating the banks, saying you have to have a more or less a final official statement prior to buying when you do the preliminary official statement. So I just wanted to give you a little history on disclosure, and from a legal perspective, and why we go about doing it, because people want to, just like when they evaluate corporations, corporations have filings that they take place, and that there's quarterly filings and annual filings, and people evaluate stocks and bonds of corporations by these filings, and that's the same thing you're doing when you do your preliminary official statement, your official statement. So with that, I think, Tim, we may want to go to Anthony on what, from a market perspective, the marketplace, because Anthony's a financial advisor, the marketplace is expecting to see from an investment perspective.
Just want me to jump in, or you want to ask the question, Mr. Moderator? Okay. Well, also I want to thank the GFOA organization for allowing us to be up here today and for making me younger. I'm happy to know that I only have 10 years of experience now today. So I've gone back in time. If we were sitting here 10 years ago, I had this big full head of hair. I was like, it was making me like 6 inches taller. It was wonderful, a lot younger. So obviously things have changed, and hopefully people have sunglasses out there because it's the light shining off my head. But anyway, this is an important topic, and as John mentioned, it's a little bit dry. So we try to make it as light as we can, but it's very important. And the market expects information. They expect as much information as they can get their hands on. Just think, if you're an investor and you buy, let's say you buy a stock, and you buy that stock with the expectation that certain things are happening in that organization, that the financial statements you see in the annual report, to the extent you got it, are accurate. And then time goes on, you put the stock away and expect it to grow and appreciate in value, only to find out that, something happened with that company, that you didn't know about, that nobody knew about, or that the financial information that was provided wasn't complete. Excuse me. Too much cheering for the Eagles last night, sorry. That was a good win. That was a good win. We like that. But, sorry, Giant fans.
You'll never get hired north of 195.
I'm also a Red Sox fan, so that kind of pushes me.
Wow.
All right, I'm a Devils fan, too. All right, so we're good.
Just really,
we got it all
really
covered. It's a tough life. But think about that. So something wasn't disclosed, wasn't provided, that would be really important to your decision to hold on to that stock or to sell that stock. So essentially the carpet gets pulled out from under your feet that, hey, I didn't know this was going on. If I knew that, I wouldn't have invested my money in this company. Same thing with your municipal bonds that you issue or your notes. The market expects to know what is going on with your community. The issue is, unlike a stock, you're not putting out quarterly results. You're putting out results once a year. And things can change, albeit, typically not much in most communities over the course of a year, but things could change. And if the marketplace is not aware of something that's very important to their investment decision, people could lose a lot of money. And so the SEC, as the enforcement arm, they determined that, the municipalities and state governments and the like may not be doing everything they're supposed to be doing to allow investors to feel comfortable with their investment, to be sure that something's not happening that could change their position on whether they should buy or hold that particular investment. So they're looking for as much information as they can get. So they're looking for your audits, your debt statements, budgets, tax-based information. All those things are important. All those things are most times readily available that can be provided. It's just a matter of making sure it's getting to the right place so that investors can see that information. Now with the advent of EMA, which is the Electronic Municipal Market Access Data Port, that's made it a little bit easier to have one place where documents go, because years ago, municipalities would have to photocopy their audit, send it to 5 or 6 different places, hope it got there, and then hope it was available to anybody who wanted to see the information. Now it's easy, it gets uploaded, but still, there's still problems with that. And there are issues that we still see where things aren't put in the right place, aren't labeled appropriately, or unfortunately in New Jersey, we have several towns with the same name, and we've seen Hamilton, for example, Hamilton, Mercer, and this is not true, this is just an example, Hamilton, Mercer, Hamilton, Atlantic, things can sometimes get confused, and perhaps documents gets put in the wrong place or gets confused. So we've seen those things before, not with the Hamiltons, but with other communities with the same names, we have seen some issues in the past. So it's important that things are done accurately and completely. So now that I've now became 10 years older with that speech. I'll turn it back to Tim for any follow-up questions.
So you can see that disclosure has evolved over time. And I think understanding, as John said, the genesis behind it. And it's interesting because when I took securities law, pre-SEC, you often hear the term the blue sky laws. The genesis of that term was the Kansas Supreme Court around the turn of the century when speculators pre-Great Depression were selling investments and properties and other things, and one of the Supreme Court justices said there's no basis in this more than there's feet of blue sky. And that was the kind of dawn of the need to have informed investors. And we're not going to get into it today, but oftentimes you see accredited investors and terms like that about who municipal obligations can be sold to. So, as John said, we have a concept of initial disclosure, and then as Anthony pointed out, these are not static investments, because in the case of municipal and county bonds, you're buying a piece of paper or several pieces of paper that have varying maturities over time. And it's not enough to say, okay, at the time of issuance, here's everything you as an investor needs to know. There's going to be ongoing and continued responsibilities. And before we get to Anthony, who's going to talk a little bit of the mechanics of how that happens, I wanted John to talk a little bit about what triggers a continuing disclosure requirement. So John, can you talk a little bit about those triggers?
Sure. So I'm going to, on top of what Tim asked me to talk about, so we did go over some initial disclosure. And obviously that's getting your bonds to market for what is, in essence, your initial public offering of your bonds to the marketplace. So you typically have a team in your communities. You'll obviously have your finance officer that you all represent out in the audience, and then you have the bond attorney, your auditor, and your financial advisor. Typically, that is your team that helps get you to the marketplace and helps you develop your disclosure or your preliminary official statement and your official statement to go to market in order to provide disclosure on your community. So when you make that initial disclosure, so the initial purchasers of your bonds or notes can evaluate the risk or the credit of your community. You also are obligating yourself, because the securities laws are required or rules require it, to do continuing disclosure on an ongoing basis. And so you have what's called a continuing disclosure certificate, a continuing disclosure agreement, and what that is typically either put as an appendix in your preliminary official statement that your bond counsel more than likely develops for you, and or it is put in as a description of what you're going to obligate yourself going forward to. So like we talked about, the whole purpose of disclosure is so people can evaluate the merits and risks of that investment before they purchase it, whether it's initially or later on. So the continuing disclosure requires you to do that throughout the life of the bonds until they're paid off or they're refunded. The reason for that, and again, we're going to go back into this, is, as you guys know, your mayor and council or township committee or freeholders sometimes make crazy decisions and raid the fund balance during crazy times and do things that you scratch your head about. Well, investors want to know that as well. And they want to know if the governing body and the government is performing in a way that they're going to pay back those bonds over the life of the issue. So that's why you have continuing disclosure. So on an annual basis, you typically have to file your audit. If your audit doesn't come out in time, you usually have to file your annual financial statement, your annual debt statement. So that is usually due within around September. Every continuing disclosure agreement's a little bit different, but most of us have kind of moved to a September standard. I'm just using the month as a benchmark, where you'll have to file your audits by that time. If you haven't filed them, typically the agreements say that you have to file your unaudited financial statements, like your annual financial statements, your annual debt statements.
Right, on that, the market.
Wait, it's not your turn.
It's okay. You can rebut my comments if you like. With that,
Chair, can you do something about this?
I am clearly failing in my role as moderator. I missed that local finance board gavel.
Go ahead.
Well, I want to point out the market looks for unaudited documents in lieu of an audit. And in New Jersey, usually you have your audit, but usually you don't have unaudited financials months before your audit's completed. So the market has accepted the annual financial statement for the unaudited documents, even though it's not a complete audit. It doesn't have all the schedules that an audit has. They do accept that. So between the annual financial statement, your annual debt statement, and then some disclosure certificates require your budgets as well. So the key is to provide information. Whether it's you have an audited document, a draft audit that can be put up on Emma or the AFS. So I just wanted to jump in with that. Sorry, John.
Okay. I forgive you. In your continuing disclosure agreement, you also, in addition to that annual information, so now this gets placed on the Emma data port, and we'll go into services like Anthony's firm provides or other financial advisors provide as a disclosure agent to help assist you with putting your audit up on Emma. So all investors can go to that one website. They look up your town or the particular CUSIP number, because you basically have like a social security number or a serial number for each bond. It's called the CUSIP number. They can look up their actual investment and all of the new disclosures, so they can see what's done annually for your community and what you disclosed on. And you're supposed to do that every year. On top of that, you also obligate yourselves to disclose information that was in that original official statement, such as tax collections, your top 10 taxpayers. There's a variety. Every agreement is different. And your disclosure agent, and that's what Anthony's firm does, as well as a bunch of the other financial or municipal advisors in the state, perform the task of helping you make sure that you provide the same disclosure that was in your original official statement. So in other words, they just don't want your audit, which was in the official statement. They also want additional financial and demographic data on your community every year so they can evaluate the merits and risks of the investment that they're about to make. So that is what you have to do on an annual basis. Additionally, under the continuous disclosure agreement, there is a number of what we call material event disclosure. Now, there's something really bad happens, and you have basically 10 days to disclose that on Emma. That can be anything from, I know you're getting antsy here, Anthony, and you really want to jump in, but I'm going to keep talking. So,
No comments.
So there's a like such as rating changes, and we're going to get into MCDC that Tim is going to ask us about in the future. But these were some of the things, these material event notices. I'll let Anthony go into them that tripped us up, especially during MCDC. So why don't you go ahead and talk about the material event disclosure that they have to do on an ongoing basis?
Check with the moderator first. Make sure it's okay with him.
Is that okay?
So approved.
Okay.
All right, you want to ask the question?
Nope.
No, okay, good, all right. Anybody out there remember what MCDC actually stands for? Oh, come on. Remember that? It's 5 years ago now, thank goodness. But it was the Municipal Continuing Disclosure Cooperative Initiative. Well, there's no I in MCDC.
Cooperative initiative.
There's no I in MCDC.
It's like we're like an old married, a married couple up here.
I'm losing them here, guys.
I'll Google it.
I thought I was bad with the blue sky law reference, but okay.
Yeah, there you go.
So we're gonna MCDC. Let's move on from that.
Sorry. Thank you.
Yeah, so we've established that there's only 4 letters in MCDC, okay? We got that. One thing to remember from today. But but if everybody remembers that initiative that the SEC put on all underwriters as well as municipal issuers, where you had to do a 5-year review of your continuing disclosure history and also what you said in your official statements as it relates to that. What they were looking for were the issuers who said they've done everything they were supposed to do according to their agreements, but actually didn't. And through the mass of stacks of reports that the SEC received to review what communities done, New Jersey had a bad rap. You know, New Jersey was probably one of the worst offenders statewide, where disclosure wasn't complete, and a lot of official statements had statements in it that said, "Yeah, we never missed a filing. We've done everything we were supposed to." And then as we did the analysis, I'm thinking, "Oh boy, okay, this is a little bit rough. We've missed this year, and some were okay, and some were, you know, the financials were there, but they may have missed a rating change. That's one of the requirements for material events that had to be disclosed. So it was a mixed bag. However, since that time, it's gotten better, and we're happy to report that there were only 2 or 3 entities that were handpicked by the SEC for further analysis and enforcement. The underwriters, on the other hand, there were about 72 underwriters who got slapped with fines for.
Underwriter, you want to tell them what an underwriter is?
An underwriter is a broker-dealer, a financial firm that buys your bonds or notes. And the whole idea of this exercise by the SEC was to clamp down on those underwriters who were buying bonds or notes without the issuer having completed their continuing disclosure accurately and efficiently. So these underwriters then were hit with fines for having purchased these bonds that were supposed to have had the complete disclosure but didn't. So 72 of them were fined. It was a big mess. It was a lot, you know, it was craziness. They had a firm deadline when everything had to be reported. But since that time, I'm happy to report that New Jersey issuers have improved. And one of the things that the SEC wanted to happen was that somebody gets designated as the person responsible for continuing disclosure. Because going back in time, when I was a lot younger and had a lot more hair, nobody knew whose role it was. You know, some issuers thought it was bond counsel's role. Some thought it was the auditor. Some thought it was their financial advisor. Some thought it was the administrator, or it was nobody really was sure. So since that time, it's been more defined, and the SEC and the underwriters get very happy when there's a third party that's designated to do it, because they know who to blame if something goes wrong. So that's one of the things that's come out of that.
One of the challenges of putting a panel like this together, besides having panelists that bicker in the middle of it, is actually trying to modulate the comments to the audience, because John Anthony and I know so many of you, and we know there's some municipalities and counties out there who are heavy participants in the marketplace, and you've done a lot of this, and we're trying to make sure that everyone knows why you do a lot of what's required. At the same time, some people that are in smaller municipalities may not have the exposure to this, and at some point, your governing body or your municipal advisor may come to you and say, okay, we want to issue debt, and it may not be something you're familiar with. So Anthony, if you would, can you just spend a minute or two talking a little more about Emma and the actual mechanics for how disclosure occurs?
Sure. Is everybody familiar with the Emma data port, or website, as I would call it? So that's the place where information on all your bond or note transactions that are sold to investors is maintained. The one caveat is that if you sold a note issue and your local bank bought it, or another local bank purchased it for its own portfolio, that may not be up on Emma because it's not being reoffered to investors. So the idea of Emma is to make data and information on issues and financial information available to investors, outside investors. So EMMA contains information on all your transactions, bond and note transactions, as well as the ongoing financial information, your audits, your AFSs, so on and so forth that we talked about, as well as any of these material events that we've alluded to. Like the most important one for most issuers are rating changes. If you get an upgrade or a downgrade in your rating, that's supposed to be reported within 10 business days to the marketplace. So that disclosure's there. One of the one-offs that got people not in trouble, but something that was necessary for that MCDC exercise were the ratings of bond insurers. Because going back, once again, when we were a lot younger, most issues came out to the market with bond insurance because there were 7 AAA rated bond insurers. So most issuers, even if you're a AA rated issuer, most likely buy bond insurance because insurance was cheap, because there were 7 companies out there trying to write policies, so they were giving away the insurance. The premiums were really low, but then you got to market your AAA, so you saved on interest rate. So most issuers had insurance at the time, but then what happened? Credit crisis 2008, bond insurers were downgraded multiple times from AAA, a lot of them down into junk. Those ratings were supposed to be disclosed to the marketplace. Most issuers had no idea. I don't know that AMBAC got downgraded last week. How would I know? I mean, it's not part of my job. So that's one of the things that having a third party do this disclosure for you can keep an eye on, because there still are some circumstances where the bond insurers get downgraded, or if you're part of you have bonds that have state support, like a county that issues Chapter 12 bonds. That state support is part of the rating on that issue. If the state gets downgraded or upgraded, that's supposed to be disclosed as well. So those things are filed and maintained on the EMMA website. One of the things that is important with filing information is to make sure that if you put an audit up there, each year you sort of name it the same thing, 2018 audit, as opposed to, audited financial statements, for 2017. It's too hard you want to make it easy for the investor to look on there and say, oh, here's this information, boom, boom, boom. Okay, great. As an underwriter, I can now bid on this note issue because I see that they have all this disclosed. Every time you do a note or bond issue, an underwriter is going to go through that exercise. They may do it themselves, or they may hire a third party to make sure you're doing everything you're supposed to do on a timely basis. We get calls or emails from underwriters every single transaction with questions or comments saying, oh, we don't see the 2014 audit up here, or we don't see we see that the 2014 audit was filed in November. How come there was no late notice on that? So we look at it and go back to them and say, well, I wouldn't say dummy, but dummy, do you see the AFS was posted on time? There's your placeholder. You're okay with the audit. So those things happen. They do review every single time your disclosure. And if your disclosure's not complete, or if they see a problem that hasn't been resolved, they're not going to bid. They don't want to take that risk of the SEC looking over their shoulder saying, why did you buy XYZ bonds when you know that they hadn't been doing their disclosure on time? They don't want that fine. It's not worth it to them. So they're just going to move on to the next deal. So that's an important component to remember.
It's interesting dealing with the SEC in that they evaluate what's going on a nationwide basis. So sometimes, and it doesn't happen all that often, but occasionally the SEC will discover something either in New Jersey or another jurisdiction and make the determination that there should be changes to the rules. And John, recently some of the material events were changed and expanded on. We're approaching 10 o'clock, so can you maybe just talk a couple minutes about some of those that change?
Yep, absolutely. Yeah, and just one thing. I mean, I wanted to go into. Do you mind if I talk? I'll go into this, but I just want to.
No, my plan was. It's 10 o'clock, so what I wanted to do is we're going to finish, this kind of component up, and then we'll talk about some of our experience, our collective experience, where we've seen disclosure gone wrong. I want to leave a little bit of time for Q&A, and then if we have enough time, we'll touch on one or two tax topics.
Okay. I just wanted to go into MCDC real quick, just because Anthony had talked about it, and I got to tell you, as a bond attorney practicing in New Jersey for 21 years, I'm really proud of our financial community when we all went through that together. That was a really ugly period in our history, because virtually everyone had some kind of blame to go around with respect to not providing that disclosure. And it could have gotten really messy in New Jersey, and a lot of finger pointing in terms of who was to blame, whether it was auditors, bond counsels, financial advisors, the CFOs. But nobody really did that, and we all kind of hung in there together, and we just got through the mess. So when MCDC came in and the SEC said, you've all been a bunch of bad boys and gals, and you haven't been doing what you said you're doing, and on top of that, you've put in your official statement fraudulent statements that said you've been in compliance with all of your continuing disclosure obligations. So that's securities fraud, okay? But the SEC was good, as crazy as that sounds, and said to everybody, look, we're going to give you a 5-year look back. As long as you come in and you file and you confess. I'm a Catholic boy, so you come in, you confess, and then everything should be okay. And that's what most of our clients did. We all kind of teamed up together, and again, a lot of fingers could have been pointed, and it could have gotten real messy in New Jersey, but we all hung together, and we got through it, and I don't think anybody really had any black eyes. I don't think I know, and we had a kind of joke in the bond counsel community that I don't think there was one client that I knew of, or any of us knew of, because there's not too many firms that do our type of work, that didn't have a continuing disclosure problem. So we always called them we were looking for Moby Dick. We were looking for the white whale, where's the white whale? And so everybody had a little bit of a problem there, and Tim the staff at the DCA at the time really did a great job at helping us with that too, and taking it seriously. So what I want to say before I go into the update of the rule is this is a really serious thing. When you go into the securities market with your bonds, you're posting things that have to be true and accurate, okay? And people are making a investment decision based upon that. And if it's not true and accurate, or it's incomplete, or there's misinformation, that's fraud, and you can get into a lot of trouble for that. Let's just say that. So I know we rely very heavily on your professionals, but at the end of the day, when you sign that continuing disclosure agreement, you obligate yourself, Chief Financial Officer, and your town to make sure that you're going to do this on a going forward basis. So you need to be aware of the risks that are being undertaken, and that you have a good professional team around you, because you guys have a lot of things going on in your communities. You're pulled in 50,000 different directions. And I'm not just saying this because I'm a bond lawyer, but I see it. Departments are getting smaller, your resources are getting strained, you don't have a lot of people to do it, so rely on your professional team, hire people like your financial advisors like Anthony that serve as the continuing disclosure agent. They, for, I don't know, $900 a year or something like that, I don't know what the charge is, but it's well worth the investment. And I'm not doing this for Anthony.
I should have passed them notes before that,
You have to be absolutely crazy to not recommend to your governing body, hey, we should hire this company. We have bonds in the market. I have too much on my plate. They do this all for us for a very reasonable fee, and it takes the load off of me, and knowing that it all gets done properly. And on top of that, when AMBAC or some other municipal bond company has a downgrade, or the state has a downgrade, you're not running around going, hey, I got to file that notice on Emma. That's what they're there for. They know, okay, we got to file for everybody. They're there to make sure that you're protected and that you're taken care of, because they're the market monitor. So with that, we talked about the material event notices that you're required to file within 10 days at any time. So you have your annual filing for continuing disclosure, and you have material event filing. So I just want to read off a couple of them so you kind of get a sense of what they are. There's 16 now, okay? But just for instance, if you have a principal or interest payment delinquency, you have to file a material event notice, okay? If you have a non-payment related default, you have to file material event notice. Unscheduled draws on debt service reserves, okay? You have to file a material event notice. So as soon as that happens, 10 days, it has to be on the EMA, or you have securities law troubles. So that's what companies like Anthony's company does. They make sure you call them up. You call up your bond lawyer right away and say, what do? We have a payment default. Now, we don't really usually have that in New Jersey because we have a very conservative form of accounting, and you guys are on top of things, so we don't normally have some of these problems. But with that, there's been a few new additions this year that are a little bit more troubling from our perspective, and we're all kind of working through this together to make sure that we go ahead and file when these two new rules come out. And I'll read them, but they're pretty much just dealing with new financial obligations that you've undertaken. So, okay, so the new ones are incurrence of a financial obligation I'll just say of the town, if material, so then you have to make that judgment as well, or agreement to covenants, events, or defaults, remedies, priority rights, or other similar terms of a financial obligation of the town, any of which affect the security holders if material. So if you have a financial obligation that you've undertaken, this could be anything from when you get those dumb post-it meter things that you guys, post office meter things that you guys enter into, and they file an 80/30 for a lease on a post meter or a copier. I'm not saying, but that is a financial obligation. So you get into a copier lease for 3 years, and that's a financial obligation. So then what you need to do is call your bond lawyer or call whoever. Hopefully they don't charge you for this call because it's pretty, simple. And you say, hey, we entered into a copier lease. It's a financial obligation. Is this something material that I need to disclose? Now, if you're a large community like, let's just like a county, just say a county. Is a copier lease really material? But if you're a little town, that's 1 square mile and your budget's really small and you enter into a copier lease, maybe that's more of a material thing and it just needs to be evaluated. So, and the second thing is the new material event is a default, event of acceleration, termination event, modification of terms, or other similar events under the terms of financial obligation of which the town, any of which reflects financial difficulties. So with that, I think Anthony probably deals with this the most, so I'm going to let him go into, because they're the end user of it. When this occurs, Anthony's doing the filing, and I'd like to have him talk about, is that okay, Tim?
Of course.
Yeah, about what he's seeing in terms of disclosure.
Glad I get permission every time to speak. It's like at home. So I'm way down the line at home. So with those two new obligations that John referenced, they came into effect on February 27th of this year. Leave it to the SEC to pick a leap year day, almost a leap year day. So, so February 27th, so if you issued any bonds or notes with an official statement after February 27th, you now are subject to these two new requirements. Why I say with an official statement, because if you have an official statement, you would have had to enter into an obligation to disclose events, whether they're financial or material. So what does that mean? That means that if I issued bonds on February 28th, I signed this new disclosure requirement that I have to report these two new items. What's a financial obligation? John referenced that. What they're looking for are obligations that you have that are not with an official statement. So if you do another bond issue this year, of course you're going to report that to Emma. You're going to have a new continuing disclosure obligation with it. That's not what they're looking for. They're looking for the other things that you do, whether it's a loan through the New Jersey Infrastructure Bank, whether it could be a copier or police, leasing police vehicles or something like that. Other obligations that investors may not know about. Now, whether you do a $100,000 lease, is that a material item? Could that, cripple the town if you don't pay up on that? Probably not. But I'm not making that decision. I don't think you want to make that decision whether that's material or not. Let's collectively work with your bond counsel and others to determine if this makes sense to report. Our stance usually is, well, if it's something that's an obligation that you're going to take ownership of at the end, it's kind of like a bond, you know, it's a debt obligation. So why not report it? What gets tricky here is, and what we found, and you may have gotten calls about these things or seen emails flying around, is if you're a community that's part of a regional sewage authority, for example, and you have a service agreement, whether it's a minor one or not, you're attached to that authority and they do an infrastructure bank loan, are you supposed to report on that? It's been up in the air. No firm decision has been made because everybody's talked about it and there's differing opinions. So I think where everybody's come out is the conservative approach. Like, okay, yes, even though I'm a small user of that authority, the fact that that authority did a loan, I need to disclose that that could be an obligation of my town. So that gets a little bit crazy when these infrastructure bank transactions get done and 10 communities need to report on something that they didn't even do, they have no control over, but they're attached to that authority. That's where it gets a little murky and gets a little crazy in our opinion, but we've been filing notices regarding that because we don't want somebody to come along and say, well, how come you didn't tell us about this? How come you didn't tell us that the authority did this loan and lo and behold, they default on the loan, they call on you to make due under your service agreement, and now it's an obligation of that town. So I think it's a little bit of a stretch, but you know, nobody wants to do what we had to do 5 years ago with the MCDC initiative. So that's an important component. The other thing, the default acceleration clause that John referenced, that mostly is due to if you have a direct bank transaction, a bank loan. That's where you would see an acceleration of the payments. If you had a huge rating downgrade and you had this loan from a bank, they could, in the documentation, have a clause in there that says that if you're downgraded to a certain level, you have to pay up on this obligation. We don't want this out there anymore. So that's an acceleration. So those are the kind of things that they're looking for. And of course, if you have financial difficulties, like if you're on a default situation, I think the world will know ahead of time that that's happening, especially in New Jersey. So these are important things. They're a bit of a nuance at this point, but most people are going to be affected by this as we move along. You're only affected at this point if you've issued new debt with an official statement after February 27th. So it's important that this all gets taken into account with things that you're doing. So it's important to have that communication with your bond counsel, your auditor, and whoever's doing your continuing disclosure.
That's a really interesting point because there are a lot of different professionals involved, both internal to the governing body, governmental unit, and external. We've talked about a lot of them. We talk about you as the CFO, your auditor, your governing body, your clerk, your bond counsel, your municipal advisor, and also your municipal attorney. So we have a couple minutes left, and I'll go very quickly, and then I'll ask John and Anthony to talk about some of their experience as well. But what can go wrong? Well, one of the instances that I had when I was at the division, and I don't want to embarrass anybody, and I don't want to go into this all the nuances of how complicated this transaction was, but I had my hand in a particular transaction for reasons of just the amount of money that the state was giving to a particular municipality, and we all sat around a conference table and did a read-through on a POS. As we went through it, there's language that your local attorney would have to sign off on, saying that there's no outstanding litigation that's material that would impact the ability to issue the debt or to ultimately enter into all of the agreements and issue the bonds. And, yep, okay, we're fine, and we keep turning the pages and keep turning the pages, and we finish the meeting, and I don't exactly remember when it was discovered. I don't remember whether whether it had been published or not. I think it had been. But all of a sudden, somebody read something in the paper, and it turned out that there was a gigantic lawsuit against the municipality that just had not been discussed, and therefore it had not been included in that initial disclosure of the offering statement. And in that case, I think what we wound up doing is something called stickering the book, which is basically you had to go out, and kind of goes back to the days when we used to put these things in paper, much more online now, but you have to put a disclaimer saying, hey, whoops, we forgot to do something, and that's something you really want to avoid at all costs. So that coordination function at the time of initial disclosure is hugely important. And you guys have seen some crazy stuff as well. So in the last couple of minutes we have, do you want to talk about one or both of the experiences?
Yeah, I'll grab it. All right. So, when we went through MCDC, I had the unfortunate experience of being bond counsel to one of the communities that had an enforcement action taken against it by the SEC. Nothing ended up happening in terms of fines or anything like that, but I'm going to tell you how things can go bad real fast. As a bond lawyer, you're usually, I'm not like, I tried to say I'm not like the other lawyers because, most of our stuff is feel-good stuff. We're always the guys that show up with the money and everybody's happy because they're going to get to do their new building or their new athletic fields. And, so we do a lot of feel-good stuff. Our end product is always a good thing, as opposed to like what I feel like other lawyers are always fighting with each other. And it's just, there's a lot of negative energy, and it's and you're cleaning up a mess. But even when I have to deal with cleaning up a mess, usually there's a good end product that comes with it. So we had one of our communities, and this is why I said this stuff's real, and the SEC does come knocking. So we had an enforcement action. I had no idea that our community, that this one community, and they entered into an agreement with the SEC, and they never sent it to me, their bond attorney, to review the documents before they entered into the agreement. So they passed a resolution, the governing body passed a resolution, they go through, with the agreement. And about 6 months in, all the things that they agreed to, they weren't doing. So the SEC regulator calls me up, and he's like, what is going on here? I can't even believe that nothing, he really was he very seriously concerned, thinking that something fraudulent or nefarious was going on with this community, that they did not want to comply, and that they were hiding something or doing something. So I fortunately developed a relationship with the regulator, and I said, whoa. I said, this guy is the particular person is a very prominent person in the community. He's got a good heart. I said, this has nothing to do with, I think, just an oversight, and we just let's get him through this. We got Anthony involved at the time, and he ended up taking over the disclosure, but there was not the ongoing disclosure because they kept checking. Are they disclosing on all their bond issues? When they go out to the market with a new OS, are they disclosing all their failures and things like that? So there was a number of failures that had taken place, and it was real. And it took us about 3 months to unwind this with the SEC and get everything right. But they were literally on our tails. I would say 2-3 times a week I'd get a call. What's happening with this, what's going on, and we take them through the process. And I thank God that the guy that we had was a reasonable person. He trusted me, he trusted us to get the town through the process, and we solved it, and I think everything's been going well ever since. But this stuff's real, and they're looking. So take your continuing disclosure obligations very seriously, and rely upon your professionals. Hire these continuing disclosure agents to do this job for you, because you don't want to get yourself in a mess. It's not Home Depot and go pick up a circular saw and let's build a deck. This stuff's pretty real. You really need to get your professionals engaged in on it. So
I know we've covered a lot and we don't have much time left, but I think that the moral of the story here is that we've come a long way, where the community as a whole, whether it's the issuers, the underwriters, the attorneys, the advisors, everybody wasn't really taking the disclosure seriously. And now, because of the MCDC, we all are, and we've done a lot better. I think that's important. That's an important concept. So, as a famous boxer once said, if I can change and you can change, everybody can change. So, as the theme of the week, Rocky, if anybody didn't get that. That was an obvious one. But I think it's important that we work together and we continue the complete disclosure that we're doing and stay on top of things to move forward and move beyond the past errors and continue what we're doing.
The time goes very quickly up here. It just turned to 10:20, and I think we're up. So we'll be around for if anybody has any questions and wants a little more specificity on anything. If not, thank you so much, and congratulations on another great conference.